All right, so we have Ms. Kim Neighbors appearing on behalf of the Department of Family and Protective Services, Ms. Rourke representing Ms. Hill, the mother, Ms. Craven, as the attorney for Mr. Johnson. Both Ms. Hill and Mr. Johnson are here present through Zoom. And Ms. Brianne Clark, the item for the child. And so, all right. Okay, should be simple enough. All right, so let's go and start with opening statements. Just make it brief. Just give me an idea of what you're looking for and where y'all are coming from, and just what to expect. I don't need eloquence or anything.
Understandable, Your Honor. Well, basically, what we're asking for today, our primary request of the court is to return Edward to his parents, with my client, Ms. Hill, being the primary parent, and then awarding Mr. Johnson a possession and access schedule. And the reason why we're doing that is the parties had mediated in this case on 2 separate occasions, with the most recent one being November 12th of 2019. In that mediation, there were a list of, I guess you'd say, orders that were, or I guess, list of things that Ms. Hill needed to complete in terms of services in order for the department to consider a return. And those agreements made in mediation were memorialized in the December 3rd, 2019 final order in this case. Ms. Hill has satisfied those agreements. She has been wholly compliant in those items. And so because of that, we are asking today for the child to be returned to the parents. If the court were to not find that in the child's best interest, then our alternative relief requested today would be a monitored return. However, with that monitored return, if that's the orders that the court makes, I would like specifics made as to what services are outstanding, because there has been some back and forth since mediation, since that final order, on what agreements or what things still need to be completed. So that is the request of my client today.
Ms. Craven, since y'all are aligned, why don't you go next?
I didn't hear you, Your Honor.
Oh, Ms. Craven, since y'all are aligned in this matter, why don't you tell me next if there's anything you need to add to that, or if you're in agreement.
Your Honor, we're in agreement with the petition and the information Ms. Rourke just gave you. We'd like joint conservatorship to be placed with the parents. We would like Mr. Johnson to have expanded supervised, unsupervised standard visitation. And we request this modification be granted. The child's been in care way too long, and we don't believe the department has a credible reason to keep the child from the parents at this time.
All right, Ms. Neighbors.
Thank you, Judge. As Ms. Rourke alluded to, there was a mediated settlement agreement that was completed on November 12th of this year, and it quite simply boils down to the fact that Ms. Hill has not completed the recommendations that were agreed to in that agreement. And it's not so much a question of being arbitrary, did she check a box or not. The requirement that she has not completed is essential, and it speaks to the larger issue of whether or not we can keep this incredibly medically needy child safe, and whether or not he'll be safe to go home. You know, we don't enter into these agreements lightly. We don't take the recommendations lightly, and therefore we expect strict compliance for a reason and within reason. And we believe that it's reasonable to expect that with the concerns we have about Edward, Ms. Hill complete each and every recommendation that is made, and follow through with it and show that not only has she completed, but she has, she can show that what she has done is enough to satisfy the requirements that, you know, this child will continue to stay safe and he will be safe in her care on a constant basis. And therefore, we believe that it is not in the best interest of Edward to send him home right now. We believe that there's still very important work to do.
Clerk?
Yes, Judge. I mean, as the department has stated, Edward is a medically fragile child and he has exceptional special needs. And my concern at this point is the same as Ms. Neighbors, that I have concerns regarding the parents. They've attended many of Edward's appointments. However, my concern is with their level of understanding of what his needs are and how important his treatment plan is. With this child, a lapse in care for him would not merely be negligent, but would be life-threatening.
All right, Ms. Rourke. Call your first witness.
Thank you, Your Honor. I would call as my first witness Natalie Hill.
Hill, please unmute your microphone first. Ms. Hill, if you could please unmute your microphone. Thank you. All right, if you could raise your right hand. You solemnly swear the testimony you're about to give at this cause currently at trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. You may lower your hand. Ms. Rourke, please proceed.
Thank you, Your Honor. Okay, Natalie, I'm going to ask you some questions. If at any time you have trouble hearing me or you need to repeat the question, please let me know. So first off, would you please state your name for the record?
Natalie Hill.
And you are the mother to Edward Johnson, is that correct?
Yes, ma'am.
And Quincy Johnson is Edward's father.
Yes, ma'am.
Okay. And so CPS first became involved with Edward back in May of 2018. Is that right?
Yes, ma'am.
Okay. And that was because he had tested positive for marijuana and cocaine at birth. Is that correct?
Yes, ma'am.
Okay. And at that point, what did CPS want you to do with Edward or have you do with Edward?
At the time, there was nothing that I just was released from the hospital to go home with my mother. We were supposed to be, I had to be supervised with Edward. I contact to try to get in contact. I guess she was just the investigator lady, and she never, they never contacted me back. And then all of a sudden, like 3 months later, a lady came and said that they were having problems with CPS and they were overwhelmed with things, and the caseworker was not doing her job. So she was a new, she was the new lady that was going to be investigating or whatever, or I don't know if they finally, she was the investigator.
Okay.
So, and that was it.
Hold on a second. Ms. Hill, can you talk much slower? I mean, you're talking really, really fast right now. I want to make sure the court reporter gets everything down. Okay?
Okay.
Thank you.
Let me go ahead and Natalie, let me go ahead and ask you maybe a few more like specific questions. So did CPS want have you place Edward with Mr. Johnson?
Not at first, they didn't.
Okay. When did they have you place with Mr. Johnson?
I think my baby was like 3 months old at the time. Like in September or something. It was like in September, I'm sorry. I'm almost in September.
And then Edward was removed in January of 2019 due to some allegations of physical abuse. Is that correct?
Yes, ma'am.
Okay. Then that's when, the removal happened. We came to court. And ever since this court case began, you've been working your services and been compliant with what CPS has asked of you. Is that right?
Yes, ma'am.
You've been attending visitation.
Yes, ma'am.
You've been compliant in all of the drug testing that they've asked you to do.
Yes, ma'am.
You've been going to all of Edward's doctor's appointments.
Yes.
Okay, and tell me a little bit about, so some of the comments made earlier is that Edward is a extremely medically needy child. What are Edward's medical conditions?
He has microcephalus. At this time, we're figuring that he has speech problems. He has hearing, so he has tubes in his ears.
Okay, hold on.
They're trying
Ms.
to
Rourke,
kind of
stop, Ms. I heard you talked about the diagnosis, and after that, she started kind of being jumbled. So if you can have her repeat that, please.
If you could repeat those, last I heard was microcephaly, but what did you say after that?
He has acute asthma.
Hold on a second. All right, Mr. Johnson, please don't have a bright light behind you because of Zoom. It makes it very distracting for everything. All right, thank you. Okay, please. I'm sorry, Ms. Rourke, please continue.
No worries, Your Honor. Okay, so you said he had microcephaly and what else?
All right. This Zoom works, but there's a specific order. Mr. Johnson, you can't have the camera pointing at the ceiling. Okay, please don't lean back in the chair. Okay, look, Mr. Johnson, I expect you to behave as if this was a courtroom, okay? All right, Ms. Rourke, please continue.
Okay, Natalie. So say again those medical conditions that Edward has.
Microcephalus. He has asthma. Right now, I'm not for sure if it was due or diagnosed by a doctor, but we're assuming that he
We're
has.
not getting any of this.
Okay. Your Honor, would it be easier if we conclude for today and reset to where this can be a little better? How would you like to proceed with this?
So,
Is he not getting my part? Y'all can't hear me? Do I need to move to another room?
Ms. Hill, please. Your voice is coming in garbled, so we can't take a record. So it may be no fault of your own. It very well could be the fault of our county internet connection. I mean, I'm not blaming anybody. What I'm saying is that we need to make a complete record. I think all the attorneys want a complete record for this one. So that being said, we need to make sure that everything that's being said, I mean, you have your day in court, so I want to make sure that the court reporter gets everything down. Was it coming in garbled for you guys too, attorneys?
Yes, Your Honor.
Yes, Judge.
Yes.
Yeah.
Just want to make sure it wasn't the Alex. So. All right, so yeah, off the record, Ms. Hill, does the place you're at, are you on a Wi-Fi signal or are you using just your cell phone?
Just my cell phone.
Okay, that's fine. Do you have a strong signal? Are you like 4 or 5 bars in there, or are you like 1 or 2 bars?
Oh no, I think like one, the first one.
I'm sorry.
So let me see something really quick.
No, it's okay. I just, there are things that this is part of the learning process that all courts are going through. So I guess the question is
that better?
I don't know. You would have to start talking for a bit, and I'm just trying to figure out a good solution for this one.
Hear me better now, or is it still the same? It's still the same?
Well, I can, but your video is frozen, which tells me that you're probably not getting a really good internet signal either. The alternative that I've come up with for this court is if we have problems with holding the hearing through Zoom, is we do have separate rooms in this courthouse for people to be socially distant. The rooms get cleaned regularly. I just kind of want to know the thoughts of the other attorneys. Ms. Clark, Neighbors, Craven.
Could Ms. Hill step outside? Get a better signal outside.
The question is if there's going to be free from distractions. That may be a problem as well. Ms. Hill, is there another place? Is there a place outside that is relatively
Okay,
quiet?
hold on.
If I may, aren't Mr. Johnson and Ms. Hill working in the same place? Can she join in his video?
Do they work in the same facility?
As far as I know, yes. Ms. Hill, did you hear me?
This is sign close, get out. Okay, is that better?
For now, would you be on a place, like, do you have a place you can sit in the shade? I mean, it's.
No,
gonna be-
I'm fine. I can stand.
Okay.
I'm fine, but can you hear me before I let the door go? I don't want to be locked out.
Yes, we can hear you.
Yes, we
Okay,
do.
that's fine. I'm ready. Well,
Alright.
let me go in the shade right here.
Okay. And Ms. Hill, one thing I do want to say is it's important there's not a bright light in the background or movement. All right. So I understand if you're outside, that's fine.
Is that better?
It's much better. Okay. All right, let's try this. Let's just try it again. Let's just see, Ms. Rourke. All right, so we're back on the record. So Ms. Rourke, you want to continue your questions? Last thing you were asking about, I think that I got, was she was talking about medical conditions, including asthma.
Yes. So Natalie, let's kind of pick up where we left off. So what conditions does Edward have as a medically needy child?
He has microcephalus, asthma. They're saying that he's gonna have a delay of speech. And I believe that's due because he needed ear tubes since he's been in foster care. That is just now getting recognized by Miss Matilda. And they put tubes in, so.
Recognized by who?
It was recognized, I guess, by Miss Matilda, the foster parent that he has now.
Ms. Rourke, are you getting all that?
It's kind of cuts in and out, Your Honor.
Okay.
Okay, and my boards are at like all the way up now.
No, I understand. It's the signal's not coming in through. All right. So we're gonna have to figure this one out.
So that's, just keep going.
No.
Hold on just 1 minute, Natalie.
Oh,
All right. So this is Ms. Neighbors, Clark, Craven, and Rourke. This is kind of where I'm standing on this. We're kind of in the middle of an evolution of the court system because of coronavirus. Tarrant County has submitted our plan to the OCA. The plan I submitted for the 323rd, pretty much all the issues that I did was incorporated into the plan that Judge Hennigan submitted to Austin. So I'm not too upset. Like if it gets approved as it is, the key parts that I wanted are in there. And so, but we can't start in-person hearings until that's done. And so right now we're kind of limited based on the 17th order is that all supposed to be remote. What I'd like to do is go ahead and one thing that I've noticed when people are, I guess, not in a very controlled environment, for lack of a better term, there's been a pattern of the signal being degraded. So, I mean, right now, this court is fairly flexible. Do you think we can find a time that we can, where Mr. Johnson and Ms. Hill can be like in a residence or a quiet area or something like that away from work? Because if we were holding this in the courtroom, they would have to miss work anyways, right? So I don't mind scheduling it on their day off or something like that if it fits. I mean, I'm not trying to be purposely inconvenient, but I just don't think, I think I'm probably gonna come out with a new order for this court that people can't be at work and break out just for a session here on forward. But I don't think we can go on today like this. I mean, counsel, do any of y'all think that we can proceed the way it is right now?
I don't believe we can. And also that's partly because I believe Miss Neighbors and Miss Craven both have other settings today that I don't think allow their schedules to have us continue on much longer. And going forward, you know, whether it's having my client come to one of those rooms there in the courtroom or there at the courthouse, or even, you know, I can bring her up to my office. I can take care of that because we have plenty of ability to be socially distanced in my office and make sure that there are secure internet connections with video feeds.
Yeah, why don't we do that? I think the order that this court gave most recently was saying, you know, we're providing that option for people here. We have separate rooms for parents to be in to participate. So I've asked Stephanie to come to this office or to this courtroom, and then she can reschedule a date that works with all y'all's schedule. That sound okay? I'm sorry about this. We're still
Your
learning.
Honor.
Baptism by fire. So.
Yeah.
All right, so we'll go off the record. Stephanie's been called, she's on her way. If you just hang tight. Mr. Johnson, Ms. Hill, probably a good idea for you to stay here so you can communicate, maybe if you know your work schedule, when it can all meet. I don't want to inconvenience you. I don't want to inconvenience anybody more than I have to. So if we can find a great time for everyone, then that's even better. Okay. Anything else from the attorneys that you need from me right now?
No, Your Honor.
Okay, I'm gonna put this on mute. Stephanie will come up here and sit at this bench whenever she gets to the courtroom, okay?
Okay, thank you, Your Honor.
Thank you, Judge.
Oh, I don't have to follow.
Hi, guys.
Hey.
Hello.
What are we doing?
We're looking at getting a time to reset this just because we're having some technological issues, if I can even speak, for probably, I'd say like an hour. I just want to make sure that we can find something relatively soon that works for everybody's schedule.
Okay. And that needs to be with Judge Kim?
Yes.
Okay. I can do June 22nd at 3 o'clock.
I'm out of town that day. I think I have a vacation letter on file too.
And you're out that day. but we haven't- Sorry. What about June 15th at 3 o'clock or 2 o'clock? Oh,
I'm
never
good.
mind. Sorry, Judge Kim's out. I'm sorry. Here's the deal is that we have so many juvenile settings that I have to go past that week. How about the 23rd at 8:30?
I'm in final trial in another court.
I can do July 6th or 7th. I can do July 6th at 2 o'clock or the 7th at 8:30.
Either of those is good for me.
Yeah, either's fine for me.
Okay, let's do July 6th at 3 o'clock.
Okay.
3 o'clock.
Thanks, guys.
Thank you so much.
Thank you.
Natalie, I'll give you a call later, okay?
Everyone's leaving? All right. Thanks, y'all.
Thank you. May you be excused.
Yes, I'm sorry we went through all this, but I think everyone wants a record. So, Ms. Neighbors, how have you been?
It happens. I'm alive.
Imagine what's going on down there.
It's insanity. Insane. I get emails every day from different court coordinators that are like, oh no, we're doing this. I'm like, okay, whatever.
We miss you over here.
Yeah. I miss uniformity.
They'll get it.
I miss being able to know what I'm supposed to do.
Yeah, that's part of it. But there's also, it's a learning curve to that, and the learning curve will extend.
Well, yeah, and it's frustrating too because we just had a case where y'all have one of our kids, and there can be no coordination.
Is that the one with Judge Newell? 233rd?
Is it Judge Newell? Because I only went in front of Judge Brown, but it wouldn't surprise me if it is. Let me look at.
I'm
I
working
think it
with
might be
Judge-
Judge Newell. Okay.
I'm working
Yeah,
with Judge
because
Newell.
I'm just.
Yeah, I've called him and asked, can we move his CPS case to this court while his juvenile case is pending? And that way there's kind of consistency. I think there's other children involved in that case as well. So he's looking
There's
into it.
7 of them.
Yes, right? 7, something like that. So
Yeah, that's my case. Yep.
yeah. So I think he's kind of asking around and kicking the tires and figuring out what he wants to do on that. But I think it makes sense.
I mean, we knew this was going to happen,
Mhm.
Because there are kids who roll through both systems at the same time. And
Yeah, no. And if one kid is through here and he has 7 or 6 siblings, there's a good chance the other 6 siblings will somehow wander through these halls. So I hate to say it, but
unfortunately, that is the truth,
statistic.
isn't it?
Well, anyways, well, it's good to see you.
Yep. Good to see you too. Thanks, Judge.
Thank you. Bye-bye.
Mhm.
Now you're good to go.
Hey, Richard,
Good morning.
did you get the 3914 paperwork? By
The
chance?
all the discovery stuff.
Yeah.
I just gave it to Judge Kim.
Okay, perfect. That works. Just want to make
Okay.
sure. Thanks.
should. I think I heard you last week. Somebody picked it up. Oh, I did not. Yeah, somebody picked it up. Oh. Oh.
I don't have any hearing aids. I'm gonna turn my unit off and log into yours.
Okay, yeah. All right, so Mr. Gladstone, Ms. Smith, we've got about 30 minutes until detention hearings start. So I think I know Ms. Rojas is opening up the courtroom for the parents. I don't know where the child is. So that's where we're at. Ms. Youngblood, anything I can do for you? Are you just early for detention hearings?
Sorry.
That's right.
Got an email that told me to check in at this time, so I guess I'm a little early. I can do some other stuff and check back in later, or
Check
whatever.
in for detention hearings?
Yeah, it's said that detention hearings would be now. I could have got confused and not seen the 3. I might have seen 10 o'clock when it was really 10:30.
But yeah, it's 10:30. Can Derek White?
Correct.
Okay, yeah. Savoko. Yeah, I think I have you on my docket for detention hearings at 10:30.
Okay, well, I'll just check. I'll get off if that's possible, is it? and I'll come back.
I do have a question. Those pictures behind you, is that you? Is that young Edwin?
No, that's young Christian, my son, and young Eden, my daughter, and I'm working out of the house. And so this is the study at my house.
I was hoping to see a picture of Edwin as a kid.
We look remarkably alike when we were young. So we were both blondies and tall and thin.
Yeah.
But he's now 6'8". It's still a blondie, and I'm gotten sort of some other color that's not blonde.
Call it distinguished.
Ah, thank you.
We'll see you about 10:30.
All right.
Call for that. What do you think, Kelly? You think the rule that we try it once, if it fails, then just probably will come using just that one person or everyone? Like all witnesses? For all parties? Or, I mean, it's hard to punish everyone. Like, why would you punish somebody? Like, they're like, no, I pay for AT&T to make sure it works. And I'm not using Cricket. But, I mean, are we willing to reset it 5, 6 times? Put on the child. Oh, we don't have a jacket. Ed sets up what computer?
The band set up the parents' computer every day.
Yes?
I sent out the link.
Okay.
You're all in here freaking out. And I have the truth.
Still don't have a child.
The child?
Yeah, we don't have the child.
No. I don't know why they're freaking out. They're coming in here yelling at me.
I don't know why they yell you.
They're feeding him.
Okay.
I don't want to be responsible for
All right,
his
thank
little-
you. We should just make
Where's
a
the
copy and leave it
child?
by there.
Where's the child?
We still don't have the child.
She does, she's not on?
No.
No.
Sorry, I've been working on everything.
Who's yelling at you?
Oh, they're Oh, Frank, the POs don't understand. Just set up the computer. I don't know how to do it. That's not my job.
We can train you.
No, I have enough to do. Thanks. I'm a government employee. I have enough to do. I'm going to delegate.
You're on YouTube right now.
Still a government employee.
You're a bureaucrat. Okay.
Let me go check with the judge real quick.
At the end of the day, she's a bureaucrat. She's a government bureaucrat. Dude, I got a story to tell you. I got a story to tell you later on about like your captains and chiefs and stuff. Like the whole thing about the certification. No.
Let's see if your son will see him on. Okay. We are all done. See, I'm alone. And his Rojas will get with the paperwork.
Okay.
Get everything else going.
Okay, thank you.
All right. Thank you.
Which way he gonna pop up on? One of those, anyone of he'll pop up on him?
Yeah, it usually says there's a, like I'll say detention or child.
Okay.
But I'll stay here for a few minutes to see if it shows them.
Guess he can put him in it.
Yeah. So that's the detention worker. They're getting the computer set up, so he'll be, that might be him right there.
Okay.
All right. Hold on, Adam. Have a seat right there.
All right, thank you.
There we go. We got the child. So wait on Miss Rojas, I think.
I'm here.
Okay. All right. Are we ready to proceed?
You are, Judge.
Thanks, ready.
Okay, we are. Well, the clerk took the jacket from the courtroom over the weekend. All right, let's go and get started because we're running dangerously close to detention hearings. So Ms. Smith, I may be asking you questions about filing dates and so on.
Okay.
Just to make sure, at least that way we can get started. Is that okay with you?
Yes, Your Honor.
All right, so the court will call cause number 323-113075-20. This is styled in the matter of Ivan Poe, P-O-W-E, Jr. We are here set for adjudication on this matter. So first I'd like to do is, or Ms. Rojas, I think she has that available easier. Ms. Rojas, when was this petition filed?
Petition was filed on the 10th of February.
Okay. And of 2020?
Yes, 2020.
Okay. And when was the child served?
Oh, I don't have that information. I'm sorry, Your Honor.
That's okay. I'll put you on the spot.
I don't know how to look that up, that information up. I'm sorry.
So Mary's before.
I'm looking for a cron. Usually they put in a cron. I don't have that information, Your Honor.
But do you have it by chance? All right, well, the clerk can't find the jacket and I can't go. One of the statutory requirements is for me to verify there was summons upon the child. That was timely served. And so we'll just go and recess until we can get the clerk to find the file that they've lost. All right, so I'm sorry about that. There's a statutory requirement that I have to verify summons before we can proceed with adjudication. All right, so we're on recess.
Hey, what do they mean?
Just,
Yeah.
set that chair aside right there.
See right here?
I'll just set it aside right there and we'll send you, let's go back to your room for right now. We'll get you out of the computer and call for you.
So we can go my room right now?
We'll get you back in the call for you. Sit down out there on your chair.
Yes, ma'am. It's out there. Go out there. Go out there. I mean, inside. You go out there and see them. They're real nice.
All right, I'm back. All right, Ms. Smith, Gladstone, Ms. Rojas. And we're just waiting on the child. Rojas, if you can call them, have me the child back. I don't even know why they took the child.
I'm calling them.
Of course they took the child. Rojas, like they literally have like about 2 minutes to get the child there. If not, we're not gonna be able to finish by 10:30.
They're getting him back on.
Okay.
Gotcha.
Yeah, Ms. Rose, I'm not gonna rush through a determined sentence plea. That's not fair to the child, not as serious as this is.
I've called them for them to put him back on. I'm not sure what's going on.
She doesn't have the information. All right.
No medication.
At this point, we can do adjudication and set off dispo to another day. Is that fair? We don't have time to do both.
We come back after detention hearings?
I've got, well, maybe not, because I don't know when detention hearings end, and I've got a CPS trial this afternoon. So I just don't know why they took the kid away. I don't know why the clerk took my file. Like, this is, as Kelly said, the Mondayest of Mondays. So, I mean, but I don't, as serious as this is on a determined sentence, it's not something I want to just go through the motions on. Right? So.
And Your Honor, do you want to state that he was served on the 14th of February?
Oh, I have the jacket. I have the jacket.
You have it now? Okay.
I have it now. So, okay. All right. So, all right, back on the record. Court will take notice that the petition was filed February 16th of 2020 on the petition alleging the child engaging in delinquent conduct. There was grand jury approval of this matter for determinate sentencing, and that was signed on February 20th of 2020. And then there was a summons served upon the child on February 26th of 2020, and a summons served upon the mother, Joanne Lemons, on February 26th, 2020. Whoever's in detention, you shut that door. Mr. Gaywood, please shut that door. All right, so Mr. Poe and Ms. Lemon.
Yes.
Yes, sir.
Y'all can raise your right hands, please. Do each of you solemnly swear the testimony you're about to give at this cause currently trial that you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hands. All right, so Mr. Poe, can you tell me what your full legal name is? You can lower your hand.
Ivan Poe Jr.
Okay, and what is your date of birth?
12/24/2003.
Okay. And then are you an American citizen?
Yes, sir.
All right, so a couple things I need to go over with you. I need to let you know that you are looking at, the state of Texas is saying that you committed aggravated assault with a deadly weapon. That means you intentionally or knowingly caused bodily injury to Jacob Sevdy by shooting him with a firearm. And during the commission of that, you actually used a deadly weapon, specifically a firearm. Do you understand what they're saying?
Yes, sir.
You understand that you could go to TJJD or could be committed for a period up to 20 years for this offense. Do you understand that?
Yes, sir.
Do you understand that if you do get committed for long enough that before your 19th birthday, you would have to come back and appear in front of me, and I would make the decision whether to place you on parole or to send you to TDC, which is adult prison. Do you understand that?
Yes, sir.
Okay. You understand you have the right to remain silent, that you do not have to say anything at all. However, you're willing to give up that right in exchange for me following this plea bargain agreement. So do you give up your right to remain silent?
Yes, sir.
You understand that if you do with this, there's a potential for this to be admitted into adult criminal proceedings.
Yes, sir.
Okay. Now you understand that you have a right to a trial. You do not have to agree to anything, but my understanding is you wish to accept responsibility for your actions, and that you do not require the district attorney's office to prove everything against you. They don't have to bring witnesses, exhibits. All right, please turn off that radio. So you understand they don't have to bring it, they don't have to prove this at trial against you, that because you're entitled to a right to trial. You're entitled for me to hear everything and decide whether or not you committed this aggravated assault or whether or not there was a deadly weapon used. Do you
Yes,
give
sir.
up your right to a trial?
Yes, sir.
You also understand that you have a right to have a jury make this decision where they would hear the exact same evidence. So let's say you didn't like me. You could take that decision-making out of my hands and place it in front of a jury of 12 people. They would hear the exact same evidence, the same witnesses, and they would make the decision whether or not you committed this aggravated assault and whether or not there was a deadly weapon. Do you give up your right to a jury?
Yes, sir.
You understand that you also have a right to confrontation. That means you have a right to look every accuser in the eye and face them as they're testifying against you. It could be Mr. Sevdy, it could be a witness, it could be anything else. And you would be able to face them as they're testifying against you. Do you give up your right to confront your accusers?
Yes, sir.
Sorry?
Yes, sir.
Okay. You understand that you normally have a right to appeal, but if I follow this plea bargain agreement, you are giving up your right to appeal. This will be final. Do you understand that?
Yes, sir.
Do you give up that right to appeal?
Yes, sir.
You understand I'm not required to follow this plea bargain agreement. Just because your attorney and the district attorney have come to this agreement, the court is not obligated to do so. I'm going to follow it. But you understand if I choose not to, or if I give you more than what the deal is, you have a right to withdraw your plea and you can start it back over again. Do you understand that?
Yes, sir.
Okay. All right, Ms. Lemons, you are here. Can you tell me what your full legal name is?
Joanne Lemons.
Okay. And what is your relationship to Ivan Poe?
My son.
Is your son. All right. Thank you. Mr. Gladstone, is there any reason why your client will not understand the proceedings today?
No, Judge, I can fully say that he's aware of the proceedings and understands it.
Okay. Is he fit to proceed?
He is, Judge.
All right, Mr. Poe, you're here today because the state of Texas has filed a petition alleging that you engaged in delinquent conduct. That means you committed certain actions that, if you were an adult at the time, would be considered criminal conduct and you would be before a criminal court. But because you were under the age of 17, that is why you're here in a juvenile setting. They're specifically saying that on or about January 12, 2020 in Tarrant County, Texas, that you intentionally or knowingly caused bodily injury to Jacob Sevdy by shooting him with a firearm, and that you did use or exhibit a deadly weapon during the commission of the assault, specifically a firearm. Do you understand what they're saying?
Yes, sir.
Okay. State waive opening?
Yes, Your Honor.
All right. Any exhibits from the state?
No, Your Honor.
All right. All right, so Mr. Poe, there's some things I want to go over. You here I have what's called a stipulation of evidence, okay?
Yes, sir.
You went over with your attorney certain concepts, is that correct?
Yes, sir.
Okay, so I want to go over this with you and make sure that we're on the same page for everything. All right, so Ivan, if I'm going to ask you a bunch of things and I'm going to ask if they're true or not true, okay?
Yes,
So
sir.
is it true or not true that you reside at 5849 Lincoln Meadow Court in Fort Worth, Tarrant County, Texas?
That's true.
Okay. And is it true or not true your birthday is December 24th, 2003?
True.
Now, is it true or not true that you are, I asked you about your rights, but is it true or not true that you intentionally or knowingly caused bodily injury to Jacob Sevdy by shooting him with a firearm, and that you did use or exhibit a deadly weapon during the commission of the assault, namely a firearm?
That's not true.
That is not true. Okay. All right. So are we proceeding, Ms. Smith and Mr. Glasser, are we proceeding law parties?
Yes, we are, Judge.
Yes,
Sound
Your
like
Honor.
it. Okay. So Mr. Poe, then what I want to do is explain to you something called the law of parties. All right. In the state of Texas, that there's certain criminal conduct that a person doesn't necessarily have to commit in order to have committed the crime. All right. So let me give you an example. Let's say that there's a bank robbery. It's me and Ms. Smith and Mr. Gladstone, and we decide to rob a bank. And what it is we're sitting around the table at Mr. Gladstone's house, and he's telling us about this bank, and he knows what it's like, and he knows when the money drop-offs are and when the armored truck picks it up. And Ms. Smith and I plan this out, and we go. And Ms. Smith goes inside the bank with a note, doesn't have a gun, right? I'm the getaway driver. I'm waiting outside. She gives the note to the teller. The teller freaks out. The security guard starts shooting his gun and kills a customer. Ms. Smith runs out. We don't even get any money, okay? So capital murder is while you're committing an aggravated robbery, right? That somebody dies. So you understand how there's a capital murder there, right? It was
Yes,
during
sir.
a bank robbery, somebody died. Now, do you understand that Ms. Smith didn't have a gun? She didn't shoot anybody. But you understand in that scenario, she would be guilty of capital murder.
Yes, sir.
You understand? I was a getaway driver. So in the state of Texas, anybody who participates, assists, or benefits from a crime is also legally guilty of the same crime, okay? So do you understand how in that scenario, I would also be guilty of capital murder?
Yes, sir.
You understand how Mr. Gladstone helped plan this out? Do you understand how he wasn't even there, but he would also be guilty of capital murder?
Yes, sir.
So I'm going back to your scenario. It looks like they're proceeding on the law of parties. So they're saying somehow you participated in, benefited from, planned in this aggravated assault with a deadly weapon, the shooting. So the question is it true or not true that through the law of parties, you committed this aggravated assault with a deadly weapon?
True.
Okay. And do you understand that this can result in a commitment for up to 20 years?
True.
All right. And is it true or not true that there was a deadly weapon used?
True.
So everything I said true, I asked you if it's true or not true, you said it was true. Are you saying true because it is true and for no other reason?
I got you. Say it again.
Oh, are all those things that you said true? Are you saying true because it is true and for no other reason?
Yes, sir.
Okay. Now, did anybody threaten you to say true?
No, sir.
Did anybody coerce you? That means forcing you to say true.
No, sir.
Did anybody induce you to say true? Meaning, did somebody offer you cash money or any kind of reward for saying true?
No, sir.
Was your statement of true, is it voluntary?
Volunteering?
Yes.
No, sir.
Are you voluntarily saying true?
No, sir.
Okay. So what does the word voluntary mean to you?
Volunteer is like doing stuff with it's really like doing stuff for free.
Okay, doing stuff for free. So are you saying true, like for free, or is somebody making you say true or forcing you to say true?
I'm saying it for free. Nobody making me say it.
Okay, so it is voluntary then. Is that correct?
Yes, sir.
Okay, just making sure. All right. State waive closing.
Yes, Your Honor.
All right, closing from the respondent.
And nothing, Judge.
All right. The court will take notice that there are two documents filed with the court. One is a stipulation of evidence, judicial confession, and disposition agreement. I'm informing the parties that I am signing this agreement and stipulation. And the court is also noting on this document that's been filed that the court admonished the child of everything in this document to the child on the record. And also filed with the court is the 3914 manifest. So based on the competent evidence from this hearing, the court will make a finding of delinquency. Specifically, the court will find the allegations as listed in paragraph 1 were established by the evidence. The court will also make an affirmative finding that a deadly weapon was used. That will conclude the adjudication hearing on this matter. So off the record, at this point, we've done adjudication. I'm inclined to let him go. We need to have a detention hearing. Mr. Gladstone, can you stick around to do a detention hearing on him so we can figure this out pending dispo?
Sure, Judge.
Okay. All right. So Ms. Rojas, we can do it, whatever paperwork we need, just go ahead and get that to me later.
Okay.
I'll probably go back to the office, but I can be zoomed back in.
Mr. Gladstone, I'm going to do you first since you're here in the courtroom.
Okay.
And so we're about to start in about 15 seconds.
Okay.
All right. Bradley, are you there?
Yes.
All right. So go ahead and get the next child ready. We're going to keep Mr. Poe here. He's going to be first. I'm adding him to the detention docket. And then let's just keep these kids coming in afterwards. So I guess Mr. Mayfield should be next, correct?
You said Mayfield after me on first on detention, bro.
I beg your pardon?
You said, right? You said Mr. Mayfield next after me?
Yes.
He said Mayfield next after me. I'm starting off detention. He said, all right.
Okay. So you're done until 2 o'clock. Okay. All right. Thank you. Mary, did you want to come up here? Should I start? Should I start? Sure. Okay. All right, this is the detention docket for the 323rd District Court. We're here, let's see, first for, I guess, Mr. Poe. All right, Mr. Poe, I'm Judge Kim. We just had adjudication for you. I want to let you know that this is a detention hearing. We've had detention hearings together. The purpose of this is to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days thereafter to make the same decision. Also, we'll let you know that you have the right to remain silent. However, if you give up that right, all right, so Ms. Corona. Who's Ms. Corona? Yes, who is she here for? Are you a parent or are you a victim? Are you
Parent.
You're a parent, okay. There cannot be, we're on Zoom, I understand, but you have to treat this like a courtroom. So please do not have domesticated animals in this. The camera needs to be stable and not a distraction for other people, okay? All right, thank you. All right, so you have the right to remain silent, Mr. Poe, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. You have a right to have an attorney, and Mr. Gladstone has been your attorney for at least 10 days. All right, so Mr. Poe, we just did an adjudication hearing. I just adjudicated you delinquent for the offense of aggravated assault with a deadly weapon, okay? Now, I understand the plea bargain agreement, which I have not formally accepted yet. You understand we have not done disposition, okay? So, but I understand the agreement was for probation. And so there's obviously something about the case that makes the district attorney feel like probation is appropriate for this case and to place you back in the community. So I'm going to go ahead and release you pending the disposition hearing, which we should have in the next sometime this week. All right, Mr. Poe, I want to let you know that it is in your absolute best interest to do everything right while you're being released. Okay, you understand that we don't have to. I don't have to give you the probation. I can still reject it. I can still send you to TJJD, ultimately up to TDC. Right?
Yes,
you got
sir.
that, Mr. Poe? Okay. So I'm going to go ahead and release you. We'll go ahead and release him on the monitor at this point. I know he's been here for a little while. So I'm going to release him on the monitor. We'll figure out when we can set up the disposition hearing. But Mr. Poe, I want to make sure you understand that I'm kind of giving you enough slack where you can actually hurt yourself.
Yes, sir.
So it's important that you take this opportunity to prove to me that you actually deserve the probation to convince me to follow through and give you the probation, okay?
Yes, sir.
All right, thank you, Mr. Poe.
All right.
Thank you,
Mr.
Judge.
Rojas, I just need a release order. I have the EM here for you.
thank
If you
you.
get the release order, Mary can get that signed, okay?
Okay, thank you.
Thank you. Thank you, Mr. Gladstone.
Thank you, Judge.
Thank you.
All right, Robert Mayfield.
Gotta go to the front lobby, which we're all gonna and to do the monitor, they'll do it separate. So she'll go over here with you and then they'll get it.
All right, Mr. Mayfield, I'm Judge Kim. Hello again. We're here for a detention hearing, and it's for me to make a decision whether to keep you in custody or to release you, all right? You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. You also have a right to an attorney, and Mr. Hall has been appointed your attorney. All right, so now we're approaching 172 days. Where are we?
Judge, I'll go ahead and speak up here. Can you hear me okay?
Yes, please.
Okay, thank you. All right, Mr. Hall and I have been speaking consistently, probably at least once, maybe a week or a couple weeks. We spoke on Friday last week, and then this morning I've been exchanging emails. We are working on getting some DME that he was having trouble seeing to him, and hopefully that was remedied now. We currently have a date set for June 30th as a bench trial, but not clear on what direction that will take. We have been talking, Ray and I, back and forth. So there is a dialogue still ongoing, Judge. And that's the status right now.
That's correct, Your Honor.
So how did we get this far? Like, this is still a child. We're 6 months in. I understand the offense, we're looking at a homicide, but at the end of the day, there's a presumption of innocence. And 6 months later, he's not the same child that today that he was when he came in here, and certainly not the same child from June 1st, 2018. Right? I mean, he was 14 years old at that time.
Not the same in what way, Judge?
Well, physiologically. I mean, okay. At this point in adolescence, I mean, children develop and they change. I mean, he is not the same human being a 16-year-old, almost 17-year-old is not the same human being as when they were almost 16 or 15. All right, so tell me how we're going to resolve this case.
It is a contest right now, from what I understand and speaking to Mr. Hall, and that's will be resolved by the fact finder, Judge. I'm sorry if I'm not understanding correctly.
When can we do this? Do we know?
That is something that Mr. Hall and I wanted to speak with you about regarding that. The issue that we are going to have is regarding something completely outside of our control, which is the coronavirus situation and the Supreme Court's latest order. So that's kind of playing into it. We had, Mr. Hall and I had spoken and come up with a couple of dates. We had been set for May 4th. We had been set for June, I believe 22nd. And then it was my understanding that Mr. Mayfield changed his election to a bench trial and had come up with the June 30th date. So this is not, we're not doing this by any purposeful delay, Judge.
I understand that.
Okay.
So no, it's not purposeful delay, but at a certain point, I mean, it's 2 years after the offense, right? So Mr. Hall, are you looking for a jury trial or a bench trial?
Bench trial.
Okay. And you want to do this in person or through Zoom?
We'd rather do it in person.
Okay. Are you objecting to Zoom?
Yes. And I believe the state does also.
Right. And at what date do you think we will be ready? The parties.
Does the court know when the Supreme, I think it's clear from the order that August 1st is the jury trial.
Correct.
Do you have any direction on in-person proceedings otherwise?
So the courts, each county is supposed to propose a plan to get approved by the Office of Court Administration. Our plan was submitted last week. So we're waiting on the Office of Court Administration to approve the proposed plan.
Yes, sir. Okay.
So that's where we're at. So this is, are both sides ready to proceed and we're just waiting on scheduling?
I need to look at the stuff that we couldn't open, and then we'll be ready. He's got to have a little bit of time for his mom to come down here.
We also have, Judge, I told Mr. Ray, I'm sorry to interrupt. I just want to make sure to say this. Sorry, Ray, go ahead.
Oh, go ahead.
I
can't see him though.
Who is that? Who is Jennifer White?
I have no idea.
No, I got rid of her. All right. So you were saying, Mr. Hall?
I was just saying, need enough time for his mom to get down here.
Okay.
And then Kevin was going to say something.
Yeah. And I had talked to Mr. Hall about this last week. We have CPS records that we're waiting on, but I did speak with them a week ago. So not last week, but the week prior, and they were gathering on all those. So we should have those shortly, which of course I'll immediately tender to Mr. Hall as soon as we get those. But that's the only thing we're waiting on, as long as we can get all the DME current and viewable to Mr. Hall, which I'm working with him on right now.
So Mr. Hall, is the uncle still willing to take him here locally?
Yes, the aunt and uncle's willing to have him. They can watch him 24/7 because the aunt's there all the time.
Judge, my understanding is that there are young children in that house.
Well, then the concern should be, if that's the concern from the state, y'all should be prosecuting this case. I mean, he's been here for 180 days. I mean, this case is 2 years old. And if truly the state was that concerned about protection of the public, we would do something with this case. But it's wholly unacceptable for a child to be in here for this long.
Yeah, Judge, I talked to the aunt about the young children, and she said she has no concerns, that she'll be there 24/7, watching all of them. So she's not concerned about her kids.
Well, and I'm sure Ms. Pettit wasn't concerned up until June 1st of 2018 either.
Well, again, if that's concern from the state should be doing something about prosecuting this case.
And
So
we
here's what I'm gonna do. So I'm gonna wait. So at this point, I'm seeing 172 days. This is the 173rd day he's been in here, okay, total. So, Mr. Mayfield, next Monday, I mean, I'll sign a release order at this point for you to get out next Monday. I just don't want any kid here being actually hit the 6-month mark. Okay, I'm very concerned about the public. I'm concerned because you fled, or your parents took. You know what? We'll just release today. And then, Mary, can we set this every week until it's actually tried? So my understanding is we are only doing this, the only delay on this trial is waiting for the orders from Supreme Court to allow us to do in person and then having the mom get here. Is that correct?
Yes.
No, no.
Oh, the records too.
The records and then the DME that you weren't able to view.
Yeah.
What records?
The CPS records. And then the DME that he wasn't able to view.
Did y'all ask for me to sign an order for the CPS records to be released?
We haven't received them ourselves yet, Judge. That's what I was saying. I spoke to CPS a week ago, not last week, but the week prior, and they were gathering those. I expect those in the next few days.
So I've signed an order to release the records, correct?
I'll look through what Mr. Bednar's has. I don't immediately see that. There's a lot here, but I can look through that today. And if not, get one to you.
Yes, if there has been one, please file a motion to compel and have CPS come into the courtroom on the setting or Zoom, and I'll send an order to compel them to. And if you haven't, please give me an order for them to produce the records, and I'll definitely sign that one. So we'll do this in 2 weeks. So we'll just set it for 2 weeks from now. Hopefully by then we'll have clarity from the Supreme Court as to in-person hearings. And then we can proceed, but we're just gonna set it for every Monday until we can do it. And when we do it, we're just gonna do it. This isn't fair to this child. And Mr. Boberg, I'm not counting you because you've only been in this building for a couple months now, right? I get that. This isn't your fault, but at a certain point, I think it's the court's responsibility to make sure that people actually get their day in court. So in a reasonable amount of time. So Mr. Mayfield, I'm gonna go ahead and release you to your aunt and uncle on electronic monitor. You've been level 1 pretty much this whole time. There have been no issues. I just can't in good conscience keep you here past 6-month mark. Okay?
Judge.
Your Honor.
All right, thank you.
Judge, may I just ask one thing on the date, please?
Yep.
Would you mind if we go ahead and just keep it for June 30th as we have, because we've already made arrangements with some of our witnesses for their availability.
That's fine. We'll do June 30th as the date that we keep. Hopefully you get the records. Please get me the orders to get CPS to provide this documentation to you. And then, but yeah, we'll keep June 30th and we'll just set it weekly thereafter.
We've gotten a subpoena. The records are under subpoena. Are you asking me to get an additional order?
There's got to be an order for them to be released to me.
Right. No, I'll get that for sure. But as far as compelling CPS.
So there's an order for them, the subpoena. When is the return date on the subpoena?
I believe it's for the date that we had set prior, which was the 22nd. I'll have to check though, Judge.
Okay.
I can check real quick here. Let me see.
Yeah, that's what you already issued. That's what you issued, and we'll keep it.
Okay. No, I have it set right now to return on June 29th.
The day before the trial?
Well, that was I don't think when I sent the subpoena out, we hadn't spoken about a date for the trial certain. So that's the date that we had on the subpoena when I sent it out, trying to get them here as soon as possible. So let me give them a call and make sure that those are being gathered and see if I can get a date. Maybe they've already sent them.
Just so you know your counterpart with CPS is here on the session, right? That's Elka. Just saying, okay. She's with your office for the department. So If you ever. I understand, Miss Daniel. Good to see you. At least they won't be surprised. Okay, well, I mean, that's the date on the return of subpoena. That's the date.
Okay.
I'm very displeased. Not personally, I'm just displeased about the whole situation. All right. Okay. All right, they've already removed Mr. Mayfield. Thank you.
Thanks, Judge.
Thank you.
This TI was removed. Oh, was it? I didn't sign the waiver then. Yes. Welcome. All right, Dominic Mendel.
Yes, sir.
Hello. Okay, I'm Judge Kim. This is a detention hearing. I'm here to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make the same decision. Also, we'll let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you.
So he'll be on the right, and then Judge Kim is there, and then you'll.
All right, so currently, Mr. Mandel, you are 17, turn 18 in September. Your probation is supposed to expire on June 12th. Let's see. It all started when you were 15 with an evading on foot. When you were 16, you had deadly conduct with a discharge of firearm charge, which you're on probation for. And then now, let's see, I issued a warrant for you. Mansfield PD said they had you in custody, said you were arrested just after midnight at a park in Mansfield, apparently intoxicated and banging your fists and hitting and kicking parked cars in the parking lot, damaging vehicles. Police said that you reeked of alcohol, and then as soon as they made contact, you made verbal threats saying, I'm going to kill you and cut off your head, beat you to a pulp. They arrested you and took you to Arlington Jail and then to Tarrant County Jail. You were bailed out, charged with criminal mischief, obstruction, or retaliation, given a citation for public intoxication. You could get more criminal mischief if more owners of vehicles come forward. We gave you a drug test and you're positive for THC. So you're on probation, you're drinking alcohol, you're smoking pot, and you're in a public park damaging cars and making threats to the police officers. You know what? Let's see. Ms. Lide? Or lied, I guess?
Yes, sir. Lied.
Yes. What time did this all happen?
It was just after midnight, I believe. He told me it was like 12:30.
Okay. All right. So mom and dad is here?
Yes, sir.
Okay. So what is he doing out after midnight by himself?
He was supposed to be spending the night at a friend's house.
Okay. Which friend?
I'm sorry?
Which friend? I
He'd be one of our neighbor kids.
I'm sorry?
One of our neighbors, sir.
So their parents didn't call you when he wasn't there?
No.
How old is this friend?
16.
I mean, were their parents home?
As far as we know.
Have you met their parents?
Yes.
So where's he getting the alcohol from?
We don't know, sir.
We don't know.
Where's he getting the weed from?
Obviously not from us because we don't do drugs.
Well, that didn't answer my question.
I mean, I don't know, sir.
All right, Ms. Lee, what was the underlying discharge of firearm? Was it at a house, at a person? Do we know?
I'm trying to remember. I believe that one was at the pool, in the community pool there, in the neighborhood, the HOA pool.
Were there people there? Do we know?
I don't know. I was trying to read the police report, and there was a bullet that they heard shot. The community heard shots fired at the pool. I don't know what time of day it was. I'm sorry, but somebody found a bullet lodged in his shoe when he was looking for the shots, and they later found holes in a window. I mean, there were 3 juveniles there at the pool. And Dominic was later found to be one of those juveniles. Your Honor, he normally resides with his mother. I spoke with her on Friday, and I don't know if he was visiting his dad or what this weekend.
So is this mom in here, or is it dad's girlfriend or dad's wife?
It's mom.
It's mom. Okay.
Okay.
It's fine. He's had no other problems
No,
on probation?
he's done well. He's been doing online school. He's been keeping really in good contact with me. He calls me, he checks in. He's been doing very well.
All right. So mom, dad, I'm sure you had a chance to talk to him. What was he upset about? You don't know?
We honestly haven't had a chance to talk to him since all this happened. So I'm not sure what he was upset about.
Any significant events in his life lately?
No, nothing. He's been, like she said, he's been doing really good. And, you know, he gets drug tested every month, so he's never tested positive. And he's never had an issue with alcohol. So this is all kind of new.
All right, Dominic, this is what I'm gonna do. At this point, you're almost 18 years old. You know, once you're 17, it's the adult criminal justice system that you have to deal with. I just don't know, honestly, just frankly, just man to man, I don't know what I can do for you at this point. The decisions that you make are just gonna follow you. I don't know if they're gonna file a motion to revoke your probation or anything, but you're looking at a 3rd-degree felony for making those threats to a cop. So, if it's true, allegedly. So I'm gonna go ahead and release you. I just don't know how much benefit the juvenile justice system can do for you at this point. So I hope you make better decisions, okay?
Yes, sir. Thank you.
All right, thank you. All right, John Taha Norwood.
Light is and everything. Virtual. So another one that filled off with a connection over whoever he's gonna go with.
All right. Ms. Norwood.
Yes.
We've met before, haven't we?
Who said
Have we
it?
met before?
Who said it?
Feel like you look familiar to me.
No, I have no. This is my first time in here. We're not even from here. We're from Mississippi.
Okay. All right, Ms. Norwood, this is a detention hearing. I'm here to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make the same decision. I'll let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so you're referred Sunday. Grand Prairie Police, they're saying that on Saturday at about 10 o'clock, police were dispatched for a person with a weapon call on Commodore Drive. When they got there, they talked to Tiffany Norwood. I guess that's you, Mom?
Yes.
Okay, talked to Tiffany Norwood. said that Jantaha kept hovering over the victim and bothering her while she was on the computer. Victim pushed her away and proceeded to her, Mr. Dodson?
Room, Your Honor.
The room, okay. All right. Jantaha, so she went off to the room to de-escalate. Jantaha ran to the kitchen, got a 7-inch knife, and began to chase the victim. She had her knife raised above the head. And mom says this is not the first time Jantaha has done this. All right. Diagnosed with bipolar and anger issues, concerned about the danger of the home. All right, so Mom, when did y'all come here from Mississippi?
We came back in May of last year. Well, I did. My kids didn't come back until August when it was time for school to start.
Okay. So does she have any juvenile history in Mississippi?
No, sir.
Okay. Now we talk about potential mental health issues. When was the last time she saw a doctor?
Since the COVID, she hasn't. The doctor did call last month and we talked over the phone. She was going to see her every month, but since the pandemic and everything's been going on, she's just been doing phone calls.
So the doctor's here in Texas or Mississippi?
She's here.
Okay. Is Jantaha on any kind of medication?
She is, and we are out of prescriptions as of now. They haven't refilled her prescriptions. We have it set up with the pharmacy so where when she's out of refills, they contact the doctor and let us get another refill. Well, they haven't refilled it yet. And I just got my recent message from the pharmacy on Thursday of last week. So we don't have any medication right now, but she's only been out a few days. The medicine does what it's supposed to do, but Jantasia plays a big role in the things that she does.
Right. So when did her medication run out?
She hasn't had any medicine since Tuesday, Wednesday.
Okay. So when this happened on Saturday, she was not taking her medication.
That's correct.
Okay. And the last time she saw the doctor, when's the last time her prescription was adjusted?
The prescription hasn't been adjusted. We need an adjustment, but we haven't spoken with the doctor. And I called and left a message on Tuesday, but I still haven't heard back from anybody that the doctor that she sees that prescribes the medicine at
So, Ms. Norwood, okay, I think you've lost my question. My question was, when's the last time it was adjusted?
Last year.
Like last year, November, or last year, August?
Yeah, November.
Okay, all right, so it's been way too long. So the Zoom visits the doctor is doing, she's not, or the online visits, they're not, the doctor's not adjusting it?
I haven't spoken to her this month for an adjustment. And it's time for her prescription to be refilled. Right. But I haven't been able to reach them.
Okay, so this is what I'm gonna do. I'm deeply concerned about your time. So when you're saying when your daughter's taking her medication, things are generally okay. I mean, there's some problems, but generally they're okay.
Yeah, for the most part.
For the most part. Now, I understand that you've got to be concerned for both your children.
Yes,
right?
sir.
And for everyone, and it is not acceptable to wave a knife around anybody. Okay. So I guess my next question is, are you concerned about the safety of your other daughter if Jantaha was to return home right now?
I am.
Okay, I need an honest answer. I mean, Jantaha is not what you want to hear, but your mom's being honest with you. She has to, okay? So if she was on her medication, would you be comfortable with her coming home? Or do we need to adjust it and figure out what's going on?
I think it needs to be adjusted so that we can see what's going on.
Well, I understand, okay. There is no right or wrong answer. Mom, you and I are on the same team. Okay? We're working to do what's best for your daughter, okay? I promise you that. So I'm not the enemy here. Now, the next thing I want to ask is, okay, so you're saying that your daughter has some anger issues?
Yeah.
What else has she been diagnosed?
ADD, ADHD.
Okay. Anything else?
No, sir.
Mood disorders, oppositional defiance disorder, things like that?
ODD.
Oh, she is ODD. Okay.
Yeah.
Okay. So she has trouble following the rules at home, doesn't she?
Very much so.
I understand. Can you get copies of the prescription to Mr. Dotson?
I can.
Okay. We will need that. What I am doing now is I'm ordering a psychiatric evaluation for your daughter. Okay. And there's a couple of reasons I'm doing this, Gentaha, all right? I want to explain this to you. So at this point, I'm going to detain you, and there's a couple of reasons why. All right, a couple reasons why. All right, Mr. Norwood. So one is I want to make sure you have a psychiatric evaluation so I can get a doctor's input and we can try and start working on a prescription to get more balance for you, to help you out. All right. The more important reason, though, which is the next one, is it seems like you have behavior problems at home. And since you have behavior problems at home, I want to make sure I send you back into a home that nobody's in danger. When you pick up that weapon and you start chasing your sister around, you cross the line. Okay? You create an environment that's very dangerous for other people, and I have to be comfortable about releasing you. Okay? This is a consequence of the decision that you made, which is to pick up that knife. If it was just words, it'd be a different, you and I would be having a different conversation right now. In fact, if it was just words, you and I would not be having any kind of conversation right now because the police wouldn't have brought you in. Okay? So what I need you to do is I need you, have they explained the behavior levels to you here? Yes? Okay. So I need you to be level 1 outstanding. I need you to hold it for at least 72 hours. That shows me that you can understand the rules and respect the rules and follow the rules. Because you know what? When I let you out of here and send you back to your mom's, at your mom's house, you have to understand the rules, respect the rules, and follow the rules there too. Because if you don't, then we just bring you back here. Okay. And we'll go through the cycle, and there's certain kids that come here over and over and over again. Because when they're here, they behave, and when they go home, they think their parents' rules don't count. Your parents' rules do count, okay? So it's up to you, on one hand, to be with a doctor, explain what your problems are. We can get you whatever medicine that we need. On the other hand, it's also up to you to prove to me that you can follow the rules and not be disruptive or harmful to other people, all right? Gentaha, do you understand what I'm saying? So I'm putting this all on you. You understand? I'm putting this on you to behave, to cooperate, to follow the rules. Mom, does this sound reasonable to you?
It does.
I remember when you were talking a little while ago, you said the medication helps, but large part is her decisions.
Yeah, Jantasia really doesn't care about her consequences. She'll do what she has to do to get out. Like I say, we did Hickory Trail, we did That's Baby Health. She knows what to do to get out, but then when she gets home, the second day is back to the same thing.
So Mom, if that happens, do you promise me that you will call Mr. Dotson, let him know that she is back to the same thing?
Yes, sir.
Because we'll just issue another warrant for her. Like, there are literally kids that come in and out of here several times a month because they think my rules don't apply at home. Remember earlier, Gentaha, when I was saying your mom and I are on the team against you, right? We're actually not against you. We're on the same team of doing the right thing, right? And we're not going to budge from that. We're like a wall. And you can beat up against that wall, but we're not going to move. We know what the right thing is. And as a 14-year-old girl, you need to do the right thing. Okay? You can't win this one. You can't break through this wall. Okay? So you can, if you do find here and you go home, you have problems, your mom just lets us know, and then we just bring you back here and you can prove to me again. But the next time it'll be a little bit longer, and the next time it'll be a little bit longer. We'll do this over and over again until you realize that you're a 14-year-old girl and you don't call the shots yet. Okay? Any questions for me, Miss Norwood? Young Miss Norwood. All right, thank you. So we have Osmond Osborne. Yeah, this is the one that just curious.
I stepped up. He's individual. It's like they typically do those. So that would be very.
I don't see.
Right anymore.
I don't see. Oh, I see.
Maybe looking for you. All right. So, so Mr. Osborne's here. This is where the department is conservator. Is that correct?
Yes, Your Honor.
Is the parent here also?
The grandmother is, Your Honor.
Where is grandma?
Should be Valencia, right?
She's there.
I'm looking for
I
her.
don't know if you guys can hear her.
I see a Jennifer White. That's the biological mother.
Joycelyn White is on there, Your Honor. She's the aunt.
The biological.
Valencia White, the grandmother, is on there. She just can't operate her microphone.
Okay. I see Jennifer White, a Jocelyn White, Jennifer White.
I'm on there now. Oh.
Okay, Miss Jennifer White, you have to remain still. Please do not shake the phone around. Ma'am, do not lay down. This is a court hearing.
Oh, I'm the grandmother.
Okay, Grandma,
Can you hear me now?
please not lay down. This is a.
Okay, yes, sir.
All right, thank you.
Listen. Okay. Okay, they can hear me.
Who is Jocelyn White?
I'm Jocelyn.
Who are you related?
There goes Jocelyn.
How are you related, Jocelyn? Jocelyn, how are you related to this child? Jocelyn White.
She's the maternal aunt, Your Honor.
She's the maternal aunt.
Yes, sir.
Can you hear me?
I can now.
Okay.
So, Miss Daniel, you're here for the department.
No.
I see Ms. Garcia.
No,
Haven't
sir. No, sir. I represent AJ on the CPS custody side.
Oh, that's right. You
Right,
left.
right in that
Forgot
line.
about-
Yes,
I'm
sir.
so used to you. Okay. So who's here from the department then?
His caseworker and a supervisor, Miss Garza and Miss Garcia.
Okay.
We also have, Your Honor, our one of our intake supervisors and the kinship worker and supervisor that did the home study on grandmother.
Can you give me their names so I know who's who?
Yes, the worker and supervisor is Ruth Garvey and Bernadette Mancera, and then the intake supervisor is Natasha Hall.
All right. All right. So, Mr. Osborne, this is a detention hearing. The law of Texas says when a child is brought to our detention facility, you have to see a judge within 3 business days or 2 business days. And I have to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days thereafter. I'll let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, I want to let you know you have the right to an attorney. If you cannot afford an attorney, I will provide one for you. Ms. McGonigal has been appointed as your attorney. All right, so Mr. Osborne, I'm looking, you're 15 years old. And this started the day before your birthday when you're 11, no, when you're 10. You had an assault case. Then you turned 11, you had a shoplifting case. And then you turned 13, you had an evading arrest case. We let you out. 2 months later, a criminal trespass case and a fail to ID case. They gave you DPP, deferred prosecution. About 3 months later, you're picked up for another assault case, which you got another deferred prosecution for. Then when you're 14, you pick up a theft of firearm, which you got probation for. You got out. While your theft of firearm case was pending, you got arrested for possession of marijuana, unlawfully carrying a weapon on a premises that sells alcohol. Back in May, we brought you in and you're positive for weed. He's still on probation, Ms. Washington?
Yes, Your Honor.
Okay, so he's still on probation.
Yes, Your
Welcome
Honor.
weed while he's on
Due
probation.
to expire next month.
Expires next month. Okay. So now, back in May, you were referred. There's a silver Nissan Juke going northbound on Miller. They ran the tags. The vehicle turned out to be stolen. The Osmond was in the driver's seat. They did a traffic stop. There was a car chase. Car crashed out. And then police saw you leaving the driver's side of the vehicle. You ran and you were taken into custody. I remember this one. You returned to the crash scene where it's verified you were the driver. So they were brought over here. So you're looking at a felony evading arrest with a vehicle. So I guess we let you out. Then there's an out of custody referral.
We received out of custody while he was in custody.
I'm sorry?
We received that out of custody referral while he was in custody.
Okay. All right. So it's a pass catching up with him. Malibu, Chevy Malibu failed to yield. There's a high-speed police chase on 20 and couldn't make the turn. Oh, that's right. This is one where you're the horrible driver. You crashed out trying to turn, hit a fence. A few people got out. I guess LaToya Osborne, Osborne, and Eric Carroll. Eric said Osborne was a driver. Leticia said Carroll was a driver. And they found 2 pistols with ammunition. All right, and so currently he's under conservatorship of the department. So is it my understanding he has multiple siblings? Is that right?
Yes.
Okay. So I guess my question actually is going to be for the department, since you're the conservator, you're kind of like the parent of the situation. Like, who wants to talk for the department?
I can talk, Your Honor.
Okay, Ms. Garcia. All right, so he's got multiple siblings. How old are the siblings?
Ooh, the ages, I'm gonna let Vicky give those specifics. There's
Okay.
a large range.
Okay, so the eldest is 17. AJ is 15. China is 13.
April is 11.
April is 12. Yeah, 12, I think. Nevaeh is 11.
I'm looking for the spread. I don't need the exact numbers. What's the spread of ages?
Well, they're from 17 to 1.
Okay, so there's a newborn as well.
Yes.
Yeah, this reminds me of the Page family.
Yeah.
Didn't I ask on this one to set it quick? On the motion to modify?
I have another client, Your Honor. I know you did ask for another client that I had to set that hearing quick, which has not been set.
Yeah, I mean, at this point, what would be the department's plans?
So, Your Honor, we have been working very hard to find an appropriate placement for Osmond if he is released. I believe a lot of the parties wanted us to consider a grandmother, which we did do a home study on. However, when they went out to do the interview with her, she reported she was not willing to be a placement for Osmond. We've reached out to several. We've reached out to several.
It's not your turn to talk. Ms. Garcia, I guess that wasn't really my question. My question was, what's the plan? Like, what are your intentions? I guess maybe that's a better word. What are y'all trying to do?
Okay, at this time, we would be placing him, if approved, in an RTC that is located in Houston that is willing to work with him.
Work with him for what?
They would provide him one-on-one supervision, regular individual and group counseling, substance abuse counseling, and close monitoring to ensure his success.
Okay, so.
Your Honor, if I may.
Yes.
The maternal grandmother is willing to take Osmond in her home. I'm not sure where the confusion was done or where the confusion is, but every time have spoken with her and when I visit her, she has indicated to me that she is willing to take Osborne in the home. The problem has been that Osborne has been released from detention, but the home study has not been completed according to the department on the maternal grandmother, Miss White, so that he could be possibly released to her. But in the interim, I have made contact with an auntie, that being Jocelyn White, and she has indicated that she would be a placement. She has no criminal history, no CPS history. She has 5 children, of which 2 are adults.
I'm gonna cut you off for a second. So we gotta take off the CPS hat, the Title V
Yes.
hat, put on the Title III hat. Okay, so my standard on Title III is I have to be concerned about whether he's gonna appear for court or not, likely to abscond, right? The severity and the nature of the offense. I also need to consider whether he's gonna be a danger to himself or a danger to community. That's really the meat of the test that I need to consider. So I'm not as worried about it's not the best, oddly enough, best interest is not one of the factors on releasing a child.
Okay, well, Your Honor, that was the reason why he was not released to his grandmother on Friday, because Judge Terry, well, previously, what was it, Wednesday? Judge Terry did not want to step on the foot of the CPS judge, that being Judge Brown, and put him into that home. Judge Brown has indicated that she wanted to see the home study because of concerns with the grandmother's health. And as a result of that, Osborne was not released on Friday to his grandmother. And that's kind of the reason why we're still here, because they indicated to her that they had a respite place here for Osborne to go to. But once Judge Terry released him, then all of a sudden he's in an RTC in Houston where he cannot wear a monitor or be monitored while there, the ankle monitor, so he can't be monitored while there. So I took the initiative to find a local placement here in Arlington that if, quote unquote, CPS doesn't want to approve the grandmother, there is another potential placement for him here locally.
This is department. If y'all place him in Houston, you understand you would have to bring him back for every court setting, right?
Your Honor, unfortunately, that is the only placement that is willing to take him due to his behaviors.
Well, that didn't answer my question.
Yes, we would bring him.
Your Honor, if I may, I'm not really sure why the department is wanting him in an RTC. He wasn't in custody of CPS for very long before he ran. And when he was on the run, he was in contact with Miss Washington. Miss Washington did not know that he was on the runaway because he was still in contact with her. Most children don't go to an RTC when they come into care. He's had no behavioral issues. There's nothing that Serenity House can give him that he cannot get in the community right now on probation pending court. Judge Terry said if he was to be released to grandmother, she would like an out of custody detention hearing in 10 days, to monitor how he was doing in the home. And I still feel that that's an appropriate plan. AJ wants to go to the family would like him. They've known about this potential placement for about a month, and yet we are still being told it's not approved, it's not completed, what have you. It is not fair to AJ to be sitting in detention when he's been on level 1 the majority of the time because another agency cannot get their butts together and do their job when he can go home and still get services provided through JPD and have an actual mechanism that can be used to deter him from running. OCOK can't bring him back to detention if he ran from their placement. If he runs from grandma's, Miss Washington can send you a progress report and back into detention he goes, and he'll sit there at that time. I think that he needs to be released. That's what he wants. I'm concerned his behavior will decrease and escalate in detention if he remains there because that's not what he wants. I think that the court has the ability to consider grandmother as a placement as a suitable option. Grandmother has been at every detention hearing but one, and that was last week because she was at a funeral. And I think the court should release him today.
Question is probation for the theft of firearm is a 1-year probation?
Yes, Your Honor.
So how many drug tests do we give him while he's on probation?
I don't have it before me, but I remember about 3. His drug test has been clean.
Until this last one, Your Honor.
Until this last one.
Ever failed to be available to you?
No.
Like, has he been just fine on probation?
Yes, up until this whole incident happened. He's been available for my... my
Your Honor, I would
visits.
make-
His mom had been available for my visits prior to him being engaged with CPS.
I would make the argument that we're here in detention right now with these new offenses, allegedly because of CPS's involvement and maybe acting out with that. He was doing well on probation.
Yes.
I would make that argument.
Yeah, Mr. Osborne here is not the victim. All right. I mean, there are victims. He is not the victim of this. So,
Your Honor, the worker that did the home study on grandma is here on Zoom if you'd like to hear from her specifically regarding the.
it's not really, I'm not, you're putting on different hats. And I mean, I respect Judge Noel and Judge Brown, but there's this is one of those times where there's a conflict in law between Title III and Title V, between juvenile justice and child welfare. And there just is. And there's no easy way to reconcile it. As long as this is, I'd be happy sending this court to Judge Newell, this case to Judge Newell for him to handle both, or, you know, I've requested for Judge Newell to allow me to handle both sides. But I think there just needs to be continuity. Otherwise, the two, Title III and Title V, are actually in opposition to each other on this case. Like, for example, law does not prohibit me from releasing the grandma directly or any other person in the world, regardless of who the conservator is. I mean, Title III does not care who the conservator is. On the other hand, you know, you want consistency. Ms. Washington, has Mr. Osborne had any problems while he was here in detention? I see level 1-0 since May 28th.
Yeah, he's had some minor infractions that was like talking without permission, overplaying. It's nothing major.
All right, so Ms. Garcia, what you're saying is the only placement that the department can put him in is in Montgomery County.
Correct.
I think I'm stuck on this one. So I have to make, and this is just where the conflict of law is. Here's my problem. Is that before I remove, if I know that the department's going to send them to Montgomery County, then that's effectively removing him from this community, which I'm not supposed to do. The idea is to keep him within the community, if at all possible. Okay. My issue here is he likely to show up in court, or is he likely to reoffend? Is he a danger to himself or others? I looked at the victim's assistance report, and there's no restitution requested for the weapons or for the car damage. Osmond, you like it here?
No, sir.
Anything about Kimbo that you like?
No, sir.
How long you been here?
I'm not sure, Your Honor. I feel like a month or so.
31 days. All right. How many kids you see come and go?
A lot.
Is there any doubt in your mind that I would bring you back here if you mess up?
You said what?
Do you have any doubt that I'll bring you back here if you mess up?
I have no doubt.
No doubt at all. I mean, you see that with kids left and right? All these kids, man, Judge Kim brought me back here, right?
Yes, sir.
Good. Well, here's the thing. And I'm going to talk, you're 15, but I think you're a little more mature than most 15-year-olds just because of what's gone in your life. I'm just going to shoot straight with you, okay? I'm not very optimistic about you. I think you make a lot of bad decisions. I think you were on a fast track to going to TJJD. I think you and I will have a conversation pretty soon where I send you to TJJD. I'm not saying it's going to happen. I'm saying if you keep on doing what you're doing, I will look you in the eye and saying, I'm committing you to TJJD, right? And you know enough about me to know that I'm not going to lose sleep if I do that, because I'm going to feel like that's the best thing for you, okay? I will send you to TJJD if you prove to me that I cannot keep you in the community. Now, if you show me a reason why I can keep you here with family in the community, then I will, because that's what the law says I have to do, okay? But if you keep on proving to me that you're going to make bad decisions, going on car chases, running from the police, giving bad info to the police, carrying guns, all these things, right? If you keep on doing this, then I will send you to TJJD. I'm not going to lose sleep over it. Because I'm going to say, he told me, he basically showed me that this is what I have to do, right? In the meantime, I have to make a finding. I don't think that you're going to run from court. I have every reason to think that you'll appear in court when you have to. I don't know if you'll be a danger to the community or to others. Your behavior level has been fine here for an extended period of time. I think that you're going to follow the rules and you're not going to break the laws, is my guess on what you showed me, okay? So at this point, if I release you, now to decide who to release you to. The law says I have to keep you in the community if at all possible, right? If CPS is telling me the only way that I can release you to them is for you to be sent to Houston, that is outside our community, all right? So at this point, I'm going to go ahead and release you. So what options do we have within our community to keep them here in Tarrant County?
Grandmother or the aunts.
Okay.
Yes.
So mother, aunt, and grandma, are those three? Where does grandma live?
Grandmother lives in Fort Worth and the aunt lives in Arlington.
Okay, so they're both in Tarrant County. Obviously, mom's not in an appropriate place because there's an ongoing case that justified the removal. I get that, okay? So as the conservator, I'm not ignoring you guys. Ms. Garcia, do you have an opinion on your preference between aunt and grandmother?
Well, grandmother, like I said, Your Honor, told us last week that she was not willing. The aunt we haven't been able to run, so I cannot say.
Okay, so I guess what I'm saying is I'm about to make a decision, and as a conservator, I'm trying to give y'all a seat at the table and a voice in the matter. Do y'all have a preference on aunt and grandmother, or is it just the same to you either way?
I don't have a preference because none of them have been approved yet, so unfortunately I can't.
Okay, no, I understand. You have your own bureaucracy to deal with. All right. So Ms. McGonigal, Ms. Daniel, since both of you are attorneys for this child, do either of you all have a preference between aunt or grandmother?
I would select the maternal grandmother, Miss White. She also has a common law husband in the home with her who's been there for 20 plus years.
What is Jennifer White doing with her screen?
Who's able to help with AJ.
Jennifer White, I'm about to kick you out of this hearing if you don't do something with your phone.
Your Honor, I believe grandma is actually on that one.
They're gone. All right.
Your Honor, and I would second Ms. Daniel about grandmother Valencia, right? AJ's represented that he wants to go with her, and Ms. White, Valencia, right, has been.
Yeah, he hasn't proved he makes good decisions. I'm not really concerned about what he wants.
Well, I'm also saying that she's also been in contact with Miss Washington. They seem to have a relationship to be able to work together.
Ms.
I don't know if Ms.
Your preference? Oh, your microphone's off. You're muted.
Okay, the grandmother.
Grandmother? Let's try the grandmother. If it's not working out, then we can switch to aunt. I'm not comfortable with mom. Obviously, the department had good enough reason to get a judge to sign the removal. I'm 100% on board with that. And so,
Your Honor, can we ask grandmother here if she's willing to have him just to make sure? Because like I said, she told us she wasn't last week.
yeah, if it makes you feel better. Grandma, are you here?
She has a hard time with her phone, if anyone can hear me. So if it was shaky or anything like that, it could be due to her MS.
No, it was.
No.
It wasn't shaky. It wasn't that it was shaky.
Okay.
All right, Grandma, can you unmute your microphone, please?
Unmute.
Okay. So Ms. Garcia was wondering, are you willing to take Your grandson?
Yes, I'll take him.
Okay. Now you understand that if he's acting up or being disrespectful, that you need to call Miss Washington and let us know.
Yes, sir. I will do that.
I need your promise on this one, Grandma.
I promise I will not tolerate it. I will not tolerate it at all.
All right. So Osmond, you understand, I believe your grandma. She does not, she is your grandma. She already did her job with her kids. It is not her obligation to tolerate your shenanigans. You understand that?
Yes, sir.
That means sneaking out at night. That means talking to people you're not supposed to be talking to. Like whatever she says goes. You understand that?
Yes, sir.
She's not your parent. She doesn't have a responsibility. She's doing this because she loves you. Your job is to make her life easier, not harder. Do you understand?
Yes, sir.
If you're out there to make people's lives difficult, you can do it to our detention staff here at Kimbo. Okay?
Yes, sir.
That's where they get paid to deal with difficult kids. You understand?
Yes, sir.
Okay. All right. So I'm releasing at this point to Grandma, just based on the findings that I'm required to make under Title III. I would love to have more information or be able to do more holistically for this child, but unfortunately just unable to. All right.
Yes, sir.
All right. Thank you.
Judge,
Thank you.
Judge, do you want AJ on a monitor?
Yes, he is on a monitor. I already checked that out and filled out that form.
Okay. I
Yeah,
just
you
wanted to
have a very strict guideline. You're on the electronic monitor. What do you think is going to happen if you cut off that monitor?
End up here, but
You end up here. What happens if you cut off the monitor and throw it away?
End up here. I'm not going to
You end up here, and I don't let you out until somebody comes up with the $1,400 it costs to replace it. You understand that?
Yes, sir.
So if you get rid of it, you destroy it, somebody has to come up with the money and pay for it before I give you another chance. You understand, right?
Yes, sir.
And here's a tip for you. If you have the monitor on, let's say somebody accuses you of doing something, you can tell Miss Washington, look me up. My monitor tell you I was at home this whole time. Use it to prove. If you're doing right, you got nothing to worry about. You understand, right?
Yes, sir.
Okay. All right. Thank you.
Thank you,
Thank you, Your Honor.
Your Honor.
Thank you. And Derek White.
So what I do, go pick him up?
Okay, hang up, Mama.
So Josh, what I do, pick him up?
Hang up, Mama.
Oh, okay, then hang up.
All right, Mr. White, I'm Judge Kim. This is a detention hearing. I'm here to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make the same decision. I'll let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. You know, for an attorney, I'll provide one for you. Mr. Youngblood has been appointed for your attorney as of today. All right, so you turned 17 in August.
Yes, sir.
All right, so you're almost there. Let's look at your history. So you were 10 years old. No. So you were 9 years old when you had a problem. We brought you in for an intervention. And evidently that did something right because you, when you're 14, you brought in for a terroristic threat and a harassment charge. Then they were dismissed for DPP. Then you're 15, you had a criminal mischief of $750 to $2,500, a theft of property. But we let you out on that. While that's pending, you pick up a theft of property case. We let you out on that. While that's happening, you pick up a burglary of a habitation case. You got probation for the criminal mischief. Then you turn 16. There's a probation violation for assault bodily injury. We had to bring you back in here. Then a couple months later, you get an evading arrest, failed to ID. We let you out. In January, you have another warrant for you. So we're dealing with a couple of problems this year.
Yes, sir.
Then in March, there's an EM violation. So we went and picked you up and brought you here. So you're on probation. You're supposed to get substance abuse treatment. You ran away from the campus after 2 days. brought in February for running away for not finishing treatment. Is this one where you beg for one more chance, Barry? Like, I didn't want to send him back to the campus for another chance. Here's one kid who did that. Like, he got kicked out of the ran away from the campus. They won't take him back.
No, you ordered a placement search on this one.
Oh, we ordered a placement search. All right, so yeah, release you from detention on EM. And then a week later, March 10th, you cut off the EM and you've been a runaway for the last 3 months.
Mhm.
And then we brought you back in, you refused to take a drug test.
No, I took the drug test. I failed it.
You failed it?
Yes, sir.
Okay. What do you fail it for?
THC.
THC, all right. All right, so Kenderick, this is what I'm looking at, all right? I'm gonna be very straight up with you.
Yes, sir.
You walked away from the campus. That was the deal of your probation. You had to do the treatment. You walked away from there, gave you another chance to go back there, and then didn't make it. You cut off your EM. You've been run away for 3 months, right? I mean, that's where we're at. So one of the things I have to consider is, will you show up for court when you're supposed to? And that's
Yes,
one of
sir.
the things
May I ask you something though?
Yeah.
Like,
Well, hold on. Before you talk, I want to let you know that I don't want to hear anything about your probation violation. So if it's about not leaving the campus, cutting off your EM, don't talk to me about that, because I don't want you to put yourself in a spot. You know what I'm saying?
It's not about that. I was just trying to tell you, like, when I need my PO, he's not there, you know?
All right, so let me break this down for you, okay? So Ronnie Mitchell's your PO, right? I will straight up tell you that what you're asking me to do is decide between Mr. Mitchell, who comes in contact with me, tells me stories about his clients, gives me updates, answers tough questions that I give him, versus a kid that I told him I would let him go if he's abided by the monitor. Then he cut off the monitor and ran for 3 months. Who do you think I'm going to believe right now?
Yeah.
Right. But why? I mean, let's talk this through. Why do you think one person has more credibility than the other?
Cause he got more power than I do.
Nah, it's not about power.
That's what I think. That's just.
I think it's, you know what it is? Okay, so let's put it this way. It's not about power. It's about the fact that one person's been straight up with me in the past and one person has not. See, what I want you to understand, Derek, is that life is a series of decisions that you make. And by your decisions, people see you and decide whether or not you're a trustworthy person. The more deceitful you are to other people, right, the less other people will trust you. That's just the way life works. Think of it this way, right? What if I told you last time when I released you on monitor that I'm going to release you on monitor and then refuse to sign the paperwork? You went out that room, you went back to the holdover back in March and said, well, I'm going home on monitor because Judge Kim told me. I just changed my mind. I never told you. What does that do for my credibility? See what I'm saying?
Yes, sir.
But that's the way, I mean, you're growing into a young man, right? I mean, you're getting older now. And one thing I want you to understand, and this is why I want to take this opportunity about Mr. Mitchell and you. I want you to understand that it's your behavior, it's your decisions every day that give you credibility. That's what makes people want to trust you and respect you, is the fact that you're consistent. My problem right now is the fact that you cut off the monitor and ran for 3 months. Like, you know, how am I supposed to do anything with the case if you're on the run, right? I mean, see where I'm going? So the detention part, that's about you running. That's the part that bothers me. That's what upsets me, is you ran for so long. Okay? And that's why I'm keeping you. Now, when you're talking about Mr. Mitchell not being available, I don't know if that's true or not. But right now, if I have to, it has nothing to do with my decision. Even if he wasn't available, that doesn't change the fact that you cut off your EM. In fact, if he was so unavailable and it was so important for you to talk to him, you would have kept your EM on and walked up here to Kimbo and said, I'm not leaving until I see Mr. Mitchell.
Okay.
But you didn't do that, right?
I can't say what I want to say, but
I understand, and I respect that. I respect your self-control right now. I'm trying to respect you as a man. I really, really am. And there's a lot about you that I do respect, but you have to understand the world that I'm in, that I have certain rules that I have to follow. Right? I'm given by the law certain tests that I have to look at your case with, make my decision based on the test applied to your specific facts, right? So it's not personal with you, but I want you to understand it's cutting off the monitor is really why you're keeping you here, okay? The whole stuff with Mr. Mitchell, it was just me having a conversation with you, hopefully to make you understand a little bit more, like as you become a grown man, entering that stage of your life, that you understand a little bit more about how relationships work. Okay? All right. So for right now, I'm keeping you, but I need you to prove me. I mean, you got to prove better. I mean, you were gone for 3 months, right? I'm not going to keep you. That doesn't mean I'm going to keep you here for 3 months. It just means you were gone for 3 months. So I'm really, really shy about letting you go right off the bat. Okay?
Yes, sir.
All right. Thank you, sir.
Appreciate it. I love you, Mom.
Love you too. They gonna keep him for a week.
Oh, did they ever, Mr. Mitchell, did they find his monitor?
I got the plug.
The plug's not what cost $1,000.
I know it. He took it, he cut it off and threw it somewhere. But I had the plug that came to it. That's it. I don't know where he threw it at.
We're gonna have to figure something out one day.
But I still had a plug though.
We should take like deposits on these monitors. All right. Thank you, Mr. Mitchell.
Thank you, Your Honor.
All right, so Rodney Moore is the last one, right?
He's under 14, Judge.
Yes, he is. So then, all right, so the court will make a finding that this next proceeding involves a child under the age of 14 years old. And so while most proceedings are open to the public, now we are closing this one to the public because the court cannot find that the interests of the child or the interests of the public would be better served by opening the hearing to the public as a finding required by Texas Family Code 54.08C. So at this point, what I'm going to do, I'm going to stop the live stream, and I need basically to take an inventory now. So we have Ms. Barros. We have MF Spence. It's really on the parent. So I'm going to start removing people. Who's Brittany Bird? Okay, so.
Your Honor, if I may.
Yes.
Brittany Bird and Kenita Brown are probation officers in training with Mike Spence, so they are observing.
Okay. What about T.S. Sparks or T. Sparks or T.S. Parks? You know who that is?
I do not.
Okay, so I'm going to remove them. What about B.J. Alexander?
I believe that's a probation officer with placement.
Okay, that's fine. R.M. Curl? Okay.
That's Deputy Assistant Director Rhonda Pearl.
All right. We need to come up with some of these names, so like JPD dash or something. At least we know. All right. All right, so I'm going to turn off the live stream.